judgment in the matter of Konecny versus District Court in Brno-Venkov, Czech Republic.
Lord Jones will explain the judgment in that case.
Arrangements for the extradition of fugitive offenders within the European Union by the use of a European arrest warrant are governed by the European Council Framework Decision of the 13th of June 2002, which is implemented in the United Kingdom by Part 1 of the Extradition Act 2003. Both the Framework Decision and the UK Act distinguish between accusation warrants, under which the return of fugitives is sought in order that they may stand trial for the offences of which they're accused, and conviction warrants, under which their return is sought in order that they may serve sentences for offences of which they've been convicted. The central issue in the present case is whether the case of the appellant, Mr. Karol Konecny, should be treated as an accusation case or a conviction case. On the 12th of May 2008, Mr. Konecny, who is a Czech national, was convicted in his absence by the district court in Brno-Venkov in the Czech Republic of 3 offences of fraud committed between November 2004 and March 2005, and he was sentenced to 8 years' imprisonment. He was never questioned or arrested in connection with the offences, nor was he ever informed that he was sought for questioning in connection with these offences. He was never subject to a restriction from leaving the Czech Republic. In June 2007, he had settled in the United Kingdom. The extradition of the appellant was requested by the district court by a European arrest warrant dated the 17th of April 2013. The warrant states that it's based on an enforceable judgment, that of the 12th of May 2008, and that the appellant will be afforded an unqualified right to be retried upon return in the event that he makes an application to be retried. On the 2nd of March 2017, the warrant was certified by the National Crime Agency in the United Kingdom, and the appellant was arrested. The extradition hearing took place before District Judge Ashworth in the Westminster Magistrates Court on the 10th of April 2017. In reliance on Section 14A of the 2003 Act, the appellant argued that he was an accused person facing a prospective trial, and that it would be unjust and oppressive to order his extradition, taking into account the delay since 2004, when the offences were alleged to have been committed. The appellant also maintained that his extradition would infringe his rights under Article 8 of the European Convention on Human Rights. District Judge Ashworth ruled that it was the conviction provisions in Section 14B of the 2003 Act which were the operative provisions, and that, as a result, the passage of time to be considered under Section 11(1)(c) and Section 14 was restricted to the period from the 12th of May 2008, the date of the conviction by the District Court, onwards. He concluded that the circumstances of the delay did not justify a finding that it would be unjust or oppressive to return the appellant to the Czech Republic. He also considered that the public interest factors in favour of extradition outweighed the considerations relating to the appellant's family and private life under Article 8. In this context, he took account of the passage of time since 2004. On the 27th of September 2017, the High Court dismissed the appeal. On the 7th of November 2017, the High Court certified the following point of law of general public importance. Quote, in circumstances where an individual has been convicted, but that conviction is not final because he has an unequivocal right to a retrial after surrender, is he accused, pursuant to Section 14A of the 2003 Act, or unlawfully at large, pursuant to Section 14B, for the purposes of considering the passage of time bar to surrender. End of quote. The appellant sought and obtained permission to appeal to the Supreme Court. The Supreme Court now unanimously dismisses the appeal. At the heart of the present case lies the question whether the appellant should be treated as an accused person, in which case the passage of time since 2004, when the offences are alleged to have been committed, will be relevant, or a convicted person, in which case only the passage of time since his conviction in 2008 will be relevant. the appellant maintains that, as he has a right to be retried on his return, his case should be treated both as a matter of European Union law and as a matter of domestic law in the United Kingdom as an accusation case. The Court considers that the appellant's case founded on European Union law is not made out. It also considers that the appellant's case is inconsistent with the European arrest warrant scheme and the express provisions of the 2003 Act. The express provisions of the Act, in their natural meaning, provide a coherent structure within which to address all cases of trial in the absence of a defendant, such as occurred in this case. This case was properly treated as a conviction case, despite the entitlement to a retrial. The Court considers that the following principles should be applied by a court in this jurisdiction when seeking to characterize a case as an accusation case or a conviction case. First, the distinction drawn by the framework decision between accusation warrants and conviction warrants is a matter of European Union law. National implementing legislation should, so far as possible, be interpreted consistently with the framework decision. Secondly, the Court should seek to categorize the relevant facts by reference to their status and effects in the law and procedure of the member state of the requesting judicial authority. Thirdly, ordinarily, statements made by the requesting judicial authority in the European arrest warrant or in supplementary communications will be taken to be an accurate account of its law and procedure, but evidence may be admitted to contradict them. Fourthly, a person may properly be regarded as convicted for this purpose if the conviction is binding and enforceable under the law and procedure of the member state of the requesting authority. Fifthly, for this purpose, it is not a requirement that a conviction should be final in the sense of being irrevocable. In particular, a convicted person who has a right to a retrial may nevertheless be properly considered a convicted person for this purpose, provided that the conviction is binding and enforceable in the law and procedure of the member state of the requesting authority. Sixthly, while the view of the requesting judicial authority on the issue of characterization cannot be determinative, the question whether a conviction is binding and enforceable will depend on the law of that member state. However, the Supreme Court does accept that where a person with a right to a retrial is correctly classified as a convicted person for the purposes of the 2003 Act, this could work to his or her disadvantage in the operation of Section 14, because the passage of time prior to his conviction is excluded from consideration. This is a deficiency in the drafting of the statute, which requires consideration by Parliament at an early opportunity. However, until such time as Section 14 can be amended by Parliament, Article 8 of the European Convention on Human Rights provides an appropriate and effective alternative means of addressing passage of time resulting in injustice or oppression in cases where the defendant has been convicted in his absence. In this case, District Judge Ashworth correctly classified the warrant as a conviction warrant. The warrant indicated that there was an enforceable judgment and a legally effective conviction which would remain such until revoked. This court is satisfied that full and appropriate account was taken of the passage of time since the offences were allegedly committed, and that the appellant has not been disadvantaged in any way as a result. For these reasons, the court dismisses the appeal.
Court is now adjourned.